Last week, I was on a run listening to a podcast about the Lindsay Clancy trial, and the host said, completely in passing, she had psychosis. Not her defense says she had psychosis, not the defense is arguing psychosis, just flatly, as a thing that is true about the world, she had psychosis. And I stopped running because that is the exact question a jury in Plymouth, Massachusetts is sitting in a room trying to answer right now. That is the only question in that trial. The entire case is about her mind and whether the law can hold her responsible for what it did. And a podcast host just answered it in 4 words between 2 other sentences while I was on my run. So I came home and I started building an episode about defamation. And about a day into research, I realized I had the whole thing backwards because what the host said isn't defamation. It isn't close. There is no world in which anyone could sue over it. And I'll walk you through exactly why in a few minutes, which left me with a much stranger question, and honestly, a much better one. If the thing that bothered me is completely, unambiguously legal, then what exactly is stopping any of us? Welcome back to The Human Pattern. I'm Liv. Before we jump in, if you're curious about why people think, feel, and behave the way they do, I'd love for you to subscribe or follow the podcast. And if you find yourself leaving an episode with more questions than answers, then you're exactly where I hope you'll be. So subscribe wherever you're listening so you don't miss future conversations. And quick note before we start, there is a section in this episode about a woman who died by suicide in 2006. I'm not going to be graphic about it, and I will be brief, but I want you to know it's coming so you can decide how you want to listen. Today is a slightly different shape than usual. Normally, I take a behavior and go looking for what's underneath it. Today, I'm taking something I said out loud on a run and going looking for what's underneath that. We're going to walk through what defamation actually is, which turns out to be much narrower than most anyone thinks. We're going to look at where the line genuinely sits using 2 real cases that landed on opposite sides of it. And then we're going to get to the part I actually care about, which is what your brain is doing when it decides how carefully to phrase something. Fair warning, I'm in this episode not as the narrator, but as an example. All right, let's get into it. Let's start with what the word actually means, because it gets used constantly and almost always wrong. Defamation is a false statement of fact, published to someone else about an identifiable person that damages their reputation, made with some required level of fault. Every single piece of that has to be there. Miss one and there's no case. Not a weak case, no case. So let's run, she had psychosis through it. Is it a statement of fact? Sure. I mean, it's phrased as one. Is it false? Well, nobody knows. That's what the trial is for. Is it about an identifiable person? Yes, Lindsay Clancy. Does it damage her reputation? And that's where the whole thing falls apart. Because that statement is her own defense's argument. It's the thing that, if a jury accepts it, means she is committed to a state mental health facility instead of spending the rest of her life in prison. It's the most favorable claim anyone could possibly make about her right now. It doesn't harm her. It's the lifeline. And there's no plaintiff. Lindsay Clancy is never going to sue a podcaster for agreeing with her lawyer. And there's one more layer, and it's a big one. There's a thing called the fair report privilege, which protects you when you're reporting on what happens in official proceedings. Court filings, hearings, testimony. The whole point is that the public is allowed to know what happens in a courtroom without every journalist needing to independently verify each claim made inside it. So repeating what a defense attorney argued in open court is protected, even sloppily, even wrong. Put that together, and here's where we land. A podcaster can state flatly, as an established fact, the single most contested question in an active murder trial, and face exactly 0 legal consequences. Not probably fine, not risky but defensible, nothing. There is no mechanism. Okay, so if that's protected, what isn't? The modern shape of all of this comes from a 1964 Supreme Court case, New York Times versus Sullivan. The context matters. It came out of the civil rights era when Southern officials were using defamation suits as a weapon to bankrupt Northern newspapers covering segregation. Sue over a tiny factual error in an ad, win enormous damages, make coverage too expensive to continue. The court's answer was that if you're a public official suing over something related to your official conduct, ordinary falsity isn't enough. You have to prove actual malice. And that phrase is genuinely misleading, so let me be clear about it, because almost everyone gets it wrong. Actual malice does not mean ill will. It does not mean the person hated you. It does not mean that they were mean about it. It means they knew the statement was false and they published it with reckless disregard for whether it was true. Reckless disregard is a high bar. It's not should have checked. It's closer to had serious doubts and published anyway. That standard later got extended to public figures generally, not just officials. Then, in 1974, a case called Gertz versus Robert Welch drew the other half of the map. Private individuals don't have to clear that bar. States can set the standard lower, and most set it at negligence. Basically, did you fail to act with reasonable care? So there are two lanes. Public figure, very hard to win. Private figure, much easier. And now here's the wrinkle that matters most for anyone who talks publicly about an ongoing case, and it is genuinely unsettling. Is a criminal defendant a public figure? Think about how strange that question is. A public figure is normally someone who voluntarily stepped into public controversy. Nobody volunteers to be charged with a crime. But once you're charged, your name is in a public document. Reporters cover it, and the case becomes a matter of public concern. Courts split on this. Some treat high-profile defendants as limited-purpose public figures for the narrow subject of their case. Some hold that being dragged into the news involuntarily doesn't make you a public figure at all. And that split matters enormously because it does decide whether a person covered by a podcast has to prove reckless disregard or just carelessness, which is a polite way of saying that an enormous amount of public commentary about criminal cases is happening in a zone where nobody actually knows what the standard is. Beyond the two standards, there are three defenses that protect essentially everything else, and they're worth knowing because once you see them, you understand why almost nothing in this space ever gets sued successfully. Shield 1, fair report privilege, which we covered. If it happened in a court proceeding or an official record, you can report it. Shield 2, substantial truth. You don't have to be perfectly accurate. You have to be accurate about the sting of it. If you say someone was convicted of 3 counts and it was actually 2, you haven't defamed them because the gist of it is true. Shield 3, opinion. And this is the one people misunderstand the most. There's a widespread belief that you can say anything as long as you tack, in my opinion, onto the front of it, like it's a spell. It is not. In 1990, the Supreme Court decided a case called Milkovich versus Lorraine Journal, and it closed that loophole pretty firmly. There is no separate blanket protection just because you labeled something an opinion. What matters is whether your statement implies specific facts that could be proven false. So, in my opinion, he's a terrible person is protected because there's no fact underneath it to check. But in my opinion, he's lying about where he was that night. Implies you know something about where he was. And that's checkable. That can be defamation. The test isn't the label. It's whether there's a factual claim hiding inside. And I want to point out what these 3 shields add up to, because it is the real thesis of this. Between fair report, substantial truth, and genuine opinion, an enormous amount of speculation about criminal cases is fully protected. Not tolerated, protected. Constitutionally. The law is not a quality filter. It was never designed to be one. So let's find the line, because it does exist. On February 27, 2026, a federal jury in Boise, Idaho, returned a $10 million verdict against a true crime content creator. $2.5 million in compensatory damages, $7.5 million in punitive damages. Here's what happened. In November of 2022, 4 University of Idaho students were murdered in an off-campus house in Moscow, Idaho. Ethan Chapin, Kaylee Gonzalez, Xander Kernoodle, and Madison Mogan. About 2 weeks later, a TikTok creator named Ashley Gilliard, who described herself as an internet sleuth and used tarot readings, started posting videos naming a specific person as responsible. That person was Rebecca Schofield, the chair of the university's history department. Schofield had never met her. She was in Portland, Oregon at the time of the murders. Police confirmed that she was never a suspect. Gilliard posted over 100 videos, which included Schofield's photograph. They claimed she had a secret relationship with one of the victims and had ordered the killings to cover it up. They were viewed millions of times. Schofield's lawyers sent 2 cease and desist letters. Gilliard ignored them. Schofield sued in December 2022. She installed a security system at her home. In June 2024, a federal magistrate judge granted summary judgment on liability, finding the statements false and defamatory as matter of law, describing the allegations as oppressive, fraudulent, malicious, and outrageous. And Gilliard kept going. She kept posting after Brian Kohberger was arrested. She represented herself at trial and testified she still believed all of it was true. At trial, Schofield described losing ownership of her own face and her own name. She testified about PTSD and nerve pain. Her husband testified about severed community ties. So look at what it actually took to lose here. Not speculation, not a bad theory, not sloppiness, naming a specific private individual as a murderer with zero evidence, repeatedly, after being told to stop, and continuing after the actual perpetrator was in custody. That's the line. It's very, very far out there. And here's the uncomfortable takeaway. Almost nothing any of us says about a case in progress is anywhere near it. Not on a podcast, not in a group chat, not at a dinner table. Now, the other side, because this one is even more instructive. In 2015, Netflix released Making a Murderer. If you didn't watch it, it followed Stephen Avery, a Wisconsin man who served 18 years for a rape he didn't commit, was exonerated by DNA in 2003, and then convicted of murder in 2007. The series explored his defense's theory that police had framed him. And one of the officers portrayed in it was a Manitowoc County Sheriff's Sergeant named Andrew Colborn. He sued Netflix and the 2 filmmakers for defamation in 2018. And I want you to understand the human situation, because the judge actually wrote about it in the opinion. Colborn described being subjected to the worldwide ridicule. There were threats against his family, and the opinion contains this detail, which I have not been able to shake. While the producers were on stage at the Microsoft Theater accepting their Emmys, Colborn was at home boarding up his front door. In March 2023, Judge Brett Ludwig granted summary judgment for Netflix. Colborn had identified 52 allegedly defamatory statements. The court found none of them could support a claim. Some of what he pointed to was the series' use of music and graphics that he argued implied guilt. The court said you cannot impose liability based solely on an unnerving musical motive. Some of it was editing choices and reaction shots. Some of it was other people's statements included in the film. Some of it, the court noted, was simply true. The judge wrote something that I think is the single best summary of this entire episode. He wrote that the First Amendment does not guarantee a public figure like Colborn the role of protagonist in popular discourse, and that, in fact, it protects the media's ability to cast him in a much less flattering light. And then, later, this. Colborn's turn in Making a Murderer may not have been to his liking, but that does not make it defamatory. He also wrote that if media could portray us only at our best, we would be a country of antiseptic caricatures and less intelligent for it. So hold those two cases next to each other. A TikToker with a tarot deck loses $10 million. A global streaming platform with an 8-figure production and 52 challenge statements wins outright. The difference isn't reach. It isn't professionalism. It isn't even how much damage got done, because Colborne was genuinely damaged. The difference is whether you make a specific, checkable, false, factual claim about a specific person. Everything else, the framing, the music, the emphasis, the ominous pause, the thing you left out, all of that is protected. Which brings me to the case that I've honestly been dreading discussing. In August 2006, a 2-year-old boy named Trenton Duckett was reported missing in Florida. His mother, Melinda Duckett, was 21. She agreed to appear on Nancy Grace's program, and the interview was aggressive. Grace pressed her hard about the whereabouts and about her refusal to take a polygraph, and suggested that she was hiding something. The day the taped interview was scheduled to air, Melinda Duckett died by suicide. She was 21 years old. Trenton was never found. Her family sued Grace and CNN. And notice the theory they had to use, because this is the whole point of this discussion. They did not sue for defamation. They sued for wrongful death and intentional infliction of emotional distress, because there wasn't a defamation case. Grace had asked questions. Questions aren't statement of fact. Implication through tone and pressure and framing is exactly the category of thing the First Amendment protects. The case ran 4 years and settled in November 2010, with Grace establishing a $200,000 trust dedicated to finding Trenton, and with the family's own attorney stating that after extensive discovery, the parties agreed there had been no intentional wrongdoing, no admission of liability. And, as far as I can tell, essentially nothing changed in the industry afterward. I'm not telling you this to litigate Nancy Grace. I'm telling you because it demonstrates the gap better than anything else I found. The law has one question. Did you state a false fact about somebody? It has no question at all for, did you destroy somebody with tone? And if you're waiting for defamation law to be the thing that makes media careful, I'd stop waiting. That is not what it is for, and it has never done that job. Now, I want to get practical for a few minutes because I suspect a decent number of you make things. Podcasts, videos, newsletters, threads, posts. Almost everybody who makes things about real people has developed the same habit, the disclaimer. This is just my opinion. This is speculation. I am not accusing anyone of anything. All parties are innocent until proven guilty. A paragraph in the show notes. A card before the video. I do it. I did it about 40 minutes ago at the top of this episode. So let's ask honestly, what does that actually protect? And the answer is a lot less than people think, and not the thing people think. 4 things a disclaimer does not do. 1, the label doesn't control. We covered Milkovich earlier, but here's the practical version. A court does not ask what you called it. It asks whether a reasonable listener would understand you to be asserting a fact that could be proven false. Saying, in my opinion, in front of a factual claim does not convert it into an opinion. It just puts 3 words in front of it. Number 2, a disclaimer in your show notes does not reach your sentence. This is the one that surprises people the most. Defamation gets analyzed in context, and the context that matters most is the statement itself and what's immediately around it. A blanket paragraph sitting in a description box that a small fraction of your audience will ever open is doing very little work on a specific claim you made at minute 34. The disclaimer is in one place, the statement is in another, and they don't touch. Number 3, blanket disclaimers are weaker than specific ones. Everything on this show is an opinion and entertainment, is a claim about your entire program. Courts have not been especially receptive to the idea that you can immunize specific factual assertions by declaring your genre in advance. If you stated a checkable fact about a named person, you stated it. Announcing your genre beforehand does not retroactively unstate it. Number 4, and this is the one I'd put on a poster. A disclaimer cannot cure an implication. If you lay out fact A and fact B and fact C and then say, I'm not saying he did it, I'm just asking questions, your listener has been handed a conclusion. You built it for them. You just declined to say the last sentence out loud. Defamation by implication is a real doctrine with real case law behind it. Just asking questions is not a shield. It is closer to being the thing the doctrine exists to address. And then there's the part nobody expects. Your disclaimer might actively hurt you. Go back to actual malice, not ill will. Knowledge of falsity or reckless disregard, which the Supreme Court has described in terms of entertaining serious doubts about whether something is true and publishing it anyway. Now say this out loud. I don't know if this is true, but, or this is just speculation. You have created a record of yourself acknowledging that you had doubts. I want to be careful here because I'm not handing you a case where a court ruled exactly that. I'm telling you it's the argument a plaintiff's lawyer would make, and that isn't a stupid one. The hedge does nothing at all to the falsity element, and it may be evidence against you on the fault element, which is a genuinely strange result. The words you added in order to feel more careful could turn out to be the words that establish you weren't. So what exactly works? One thing, and it isn't a disclaimer. Attribution. The affidavit alleges he was at the scene. According to her testimony, the light was red. Prosecutors have argued that she planned it. Notice what those sentences are doing. They aren't wrapping a claim in a label. They are making a different claim. And that different claim is true. The affidavit does allege that. She did testify to that. Prosecutors did argue that. You can prove every one of those because the proof is a document. You haven't hedged. You've stated something you can actually establish. Here's the whole difference as plainly as I can put it. A disclaimer is a label you put on a sentence. Attribution is a different sentence. One changes how you feel about what you said. The other changes what you said. And that brings us to the uncomfortable conclusion, which happens to be exactly where this episode is heading anyway. Disclaimers mostly protect the speaker, not the subject. They protect your sense of yourself as a careful person. They let you say the thing and also be someone who was responsible about saying it. They are functionally a feeling, which doesn't make them worthless, and I want to be clear about that. There's real value in a disclaimer as a promise to your audience, and there's real value in the discipline of writing one, because sitting down to write it forces you to notice what you're about to do. But if you're relying on it as protection, you should at least know what you're relying on. So let's go back to my run and why that host said she had psychosis instead of saying her defense says she had psychosis. I don't think it was malice. I don't think it was even carelessness exactly. I think there are 3 things pushing on that sentence, and they're all pushing the same direction. The first is the illusory truth effect. This has been studied since the late 1970s, and it's remarkably robust. Repeated statements get rated as more true than new ones, just from repetition. It works even on people who know better, and it works even on claims the person can identify as false when asked directly. So a claim doesn't have to persuade you, it just has to keep showing up. The second is the continued influence effect. When information turns out to be wrong and you're told it's wrong, the correction does not delete the original from your reasoning. It sits alongside it. People will acknowledge a retraction and then keep using the retracted information to explain what happened. That is a brutal finding for anyone in media. It means the correction at the top of the next week's episode does not undo this week's episode. It just adds to it. And the third is the one nobody talks about, which is the format itself. Try saying this out loud. Her defense has argued that she was experiencing postpartum psychosis, though prosecutors dispute that characterization, and the jury has not reached a determination. Now imagine hearing that sentence 40 times in an hour. It's unlistenable. It kills momentum. It sounds like a legal disclaimer read by a nervous person. So, audio, structurally, rewards the confident version. The hedged version is more accurate and less listenable. And the format quietly selects for the other one every time. That's not a moral failure. That's an incentive, which is worse, honestly, because incentives don't feel like anything from the inside. Okay, here's the thing I actually came here to say. The host said she had psychosis as a flat fact. I would bet almost anything that the same host would never say she was faking it as a flat fact. Sit with that for a second, because it's strange. They're not more certain about psychosis than about malingering. Nobody is certain about either. That's what the trial is for. But one of those sentences feels dangerous to say, and the other one doesn't. And legally, they're about equally safe. Same absent plaintiff, same fair report privilege, same protected commentary on a public proceeding. You could say either one and nothing would happen to you. So the hedging instinct isn't tracking uncertainty at all. It's tracking perceived risk. We are careful where we fear consequences. We are not careful where we lack knowledge. Those feel like the same thing from the inside, but they are completely different things. And there's a second layer to it that I think is even more interesting. Notice which direction the unhedged claim ran. Toward the sympathetic reading, toward the version that helps her. We hedge much harder on claims that hurt someone than on claims that help them, which sounds like decency and mostly is, but an exculpatory claim that's false is still a false claim. And in an insanity case specifically, it isn't even neutral, because stating psychosis as established fact prejudges the exact question 12 people are being asked to decide. It's not kinder. It's just wrong in a direction that feels nice. And wrong in a direction that feels nice is one of the hardest errors there is to catch, because nothing in you flags it. There is no discomfort. The whole warning system is calibrated to a different threat. And I'd be a coward if I didn't put myself in this. And I want to be careful about how, because it would be easy to let myself off here. This isn't a show that runs through cases. The whole premise of the human pattern is that I don't jump to conclusions, that I stay curious, stay open, and follow the evidence rather than the story. When I use a case, it's because it opens a door onto a behavior. The case is the example. The behavior is the point. So it would be very easy for me to say I'm not who this episode is about. Except that's exactly backwards. Because a show built on not jumping to conclusions is a show that has to actually not jump to conclusions, out loud, 40 minutes at time. The premise isn't a shield. It's the thing that I have to keep proving. And here's what I've learned doing it. I cannot do it on instinct. I've had to write the rules down. I say the footage depicts instead of what happened was. I attribute contested claims to whoever actually made them by name. When reporting conflicts, I say so out loud instead of quietly picking the version that fits my structure better. And I say on air that I'll correct it if the record turns out different. I'm not listing those because I think they make me good. I'm listing them because they demonstrate the actual argument. The rules do the work my instincts don't. When I'm in the flow of researching an episode and a sentence has good rhythm, when the confident version just sounds better, my instincts are useless. They're calibrated for risk, same as everyone's. Curiosity as a personality trait does not survive contact with a sentence that scans well. The rule is a prosthetic. It catches the thing the instinct isn't built to catch. And here's the harder version, which I'd rather say than have you notice. I have absolutely said something on this show more confidently than the evidence supported. Not because I was reckless, because it sounded better that way. Being the person who asks questions for a living does not exempt you from this. If anything, it makes it easier to miss because you've already decided that's who you are. If you catch me doing it, tell me, genuinely. Drop in a comment or links are in the show notes. I want to know. There's a natural reaction to everything I've just said, which is fine, then change the law. Make it easier to sue. Make people careful. And I want to spend a couple minutes on why I don't think that works, because there's an active movement to do exactly that. Justices Thomas and Gorsuch have both written separately on more than one occasion, arguing the Supreme Court should reconsider the Sullivan standard. Their arguments differ, but the standard thread is that actual malice was largely a judicial creation and that the modern information environment is nothing like 1964. And there's something to that. The world where Sullivan made sense had gatekeepers, editors, fact-checkers, libel lawyers, and limited number of people who could reach millions. That's obviously gone. But here's the problem with lowering the bar. The same standard that protects a reckless podcaster is the standard that protects a reporter investigating a governor. There is no version of the rule that applies to people you dislike and exempts people you respect. Sullivan exists because Southern officials figured out that you don't need to win a defamation suit to silence a newspaper. You just need to make defending one expensive enough. Lower the bar, and the first people through the door aren't grieving families. They're the people who can afford lawyers. So I don't think the answer is out there. I think it's in here, which is much less satisfying and a lot more work. Here's your assignment for the week, and it's a small one. This week, I want you to catch yourself saying something confidently about a situation you only partly know. A trial, a news story, a conflict between two people you know but weren't in the room for. Then do the swap. Rebuild the sentence with the attribution back in it. Not, she was psychotic, but her defense says she was psychotic, and the jury hasn't decided. Not, he cheated, but she told me he cheated. Not, that company knew, but the lawsuit alleges that company knew. Now here's the actual exercise. It isn't the swap. It's noticing how much you don't want to say the second version. Notice that it feels worse in your mouth. Notice that it's slower and clunkier and less satisfying, and that some part of you experiences it as weaker. And then notice this. Every single one of those objections is about rhythm. None of them is about truth. The actual sentence is right there. It costs you nothing but cadence. That's the whole pattern. We are not trading accuracy for anything important. We're trading it for the way a sentence sounds. Now, I want you to end back where I started, on that run. I don't think that host is a bad person. I don't think they were being reckless. I think they were building a sentence that sounded right, and the confident version sounded better. And there was no force anywhere in the world pushing back on that. Not the law. We've established that thoroughly. Not their audience, because confidence is what audiences reward. Not the format, because the format punishes hedging. The only thing that could have stopped that sentence was a rule they decided on in advance, on a calm day, before it mattered. That's it. That's the entire safety system. One person deciding ahead of time how they're going to talk about things they don't know, which is not much, but it turns out to be everything we've got. 2 quick notes before I go. The Clancy trial is ongoing in Plymouth Superior Court as I record this. She has pleaded not guilty. Nothing about her mental state has been established yet, and I'm not going to establish it for you. And if the section about Melinda Duckett was hard to hear, or if any of this hit close to home, please reach out to someone. There are people whose whole job is to talk to you about it, and they are genuinely good at it. I'm happy to point you towards resources if you message me. If this episode changed how you're thinking about a story you already decided you understood, I would love to hear about it. Drop in a comment and links are in the show notes. Be sure to subscribe wherever you're listening, and if you're enjoying The Human Pattern, a rating or a review really helps more people find the show. So until next time, stay curious, question the pattern, And I'll see you in the next episode.